Hello, everyone. We hope you and your loved ones continue to be safe and healthy as we navigate through these challenging times. I am Namrata Chadda, partner at the Pharma Chemistry team at KNS Partners. In this session of WIPF, I and my colleague partner, Mr. Ravi Bhola, who is also the practice chair of the patents team, discuss some common questions, some whys, ifs, and buts around valuing patents. Patent valuation is a complicated task. There is no absolute value that can be assigned to any patent, and a lot of it is speculative. While we navigate and understand some of these technicalities, let's first understand that why one even needs patent valuation. Ravi, could you take us through the need and the reasons as to why one should consider this whole exercise?
Thanks, Namrata. As we all know, intellectual property assets such as patents are the core of many organizations and transactions related to technology. Broadly, we can categorize the need of valuing patents into three buckets for patent monetization, or for legal and financial reporting issues, or for internal use. Now, when you look at patent monetization is an important part of the managing an IP portfolio. But before pursuing a particular patent monetization strategy, his patents in various scenarios, such as obtaining venture capital investment by using patents as collateral for raising funds through bank loans, in negotiations involving sale or license of patents, and during merger and acquisitions or joint ventures. Now, in most of these transactions, organizations negotiating have to agree on a price. I believe knowing the value of the intellectual property is not only essential to reach an agreement, but also to make sure that the parties are engaging in a good deal. Further, patent valuation is a very useful tool in determining damages in legal infringement cases in scenarios of patent conflicts such as, patent infringement proceedings or even alternate dispute resolution mechanisms. Quantification of damages is often necessary as a part of the step in these such cases. The correct valuation of the patent at stake is therefore essential to guarantee a fair recovery of the damages. Further, often organizations are required to report on their assets, including their intangible assets. Valuation is therefore a necessary step even in the situations around tax planning. The third scenario that comes in when patent valuation may be needed is for internal processes or decision making. The possible scenarios could be, for example, acquiring or disposing of or restructuring IP assets, or even, for something as simple as rewarding inventors for innovations. So I would like to add here that, defining the objectives and context of the valuation is utmost critical. It helps determine the strategy as well as the type of valuation method that can be used. This is therefore the first step to be taken when performing a valuation.
Thank you, Ravi. I so agree with the statement that the context of valuation has a bearing on the final numbers. Often we get queries from clients wherein they inquire that should they consider doing the patent valuation in advance? The answer to it is a big no. Valuation should only be done when the context or premise is clear. The value assigned to any patent could greatly vary depending upon why you wish to do valuation. For example, a value assigned to a patent in an arm's length transaction could be very different from the value assigned in an infringement suit, more so if the infringement has been established. Going further, another common question that we face from clients is that the finance team already has all the data pertaining to the creation of IP. Why should they then consider doing patent valuation from an external agency? While having a patent valuation report from a neutral agency could be a law requirement, such as in cases of financial reporting, the question arises as to what if there is no such requirement. Ravi, I would like you to explain to our audience as to why they should not rely exclusively on the cost available with their financial team.
Sure, Namrita. To answer this, it will be good to understand the basic approaches adopted for doing patent valuation. When valuing any intellectual property asset, not limiting to patent, there are three principal methodologies which are often used. These are cost method, income method, and market method. These methods are sometimes, also called as classical valuation methodologies. In the cost method, the value of an asset is measured by examining the cost to recreate the exact or similar asset. Now, in the case of market method, on the other hand, the value of an asset can be measured by examining market transactions for very similar assets that may have taken place in the past. Now, lastly, as regards the income method, the value is essentially measured by examining the net present value of the predicted future income expected to be generated by the asset in question, taking into account all the risks that are inherent in achieving these future cash flows. Now let's look at each of these in detail. So when you look at the cost method, this is basically based on the principle of determining how much the patent or its close alternatives cost to reproduce. You can say it is similar to a situation where a home buyer decides how much it will cost him to build a new house similar to the existing one. Now the advantages of having a cost approach is that it is relatively easy to calculate. Your finance team would have it readily available in their system. It can sometimes serve as a useful tool for valuing assets such as computer software, which are reproducible products in that sense. Now, on the other hand, the disadvantages of the cost approach is that it has little to no relationship to market value. It does not consider obsolescence in any sense whatsoever. Now, the cost method also does not take into account the income generating capabilities of the asset. You just think of it. How much money that asset can generate in the marketplace is not really a consideration under the cost method. So that's where the challenge comes in. Hence, it is not used much except for certain very limiting circumstances and only essentially as an additional guide for other well-known methodologies. Now let's look at the other methodology, which is market method. The market approach focuses on determining what others have paid for a comparable intellectual property asset. So think of it. If someone has sold a 3-bedroom apartment for, let's say, $100,000, it will be helpful to determine rates of properties in the same locality, whether of similar size or smaller size. So you have a reference point essentially. Now, while house rates are often easier to get, the same is not true for patents, as you can imagine. Patent transactions are not available on open resources, and we have to often rely on specialized data sources, databases for extracting these transaction details. They could be, be it from, corporate annual reports, for example, or, specialized royalty rate databases such as, KT Mine is pretty popular, or even Royalty Source is very popular. Now, some decided court cases can also help, particularly in terms of determining the licensing rate or damages which are calculated in case of the infringement. Now, what is important is we have to understand that the market approach works very well when market data is readily available. Okay. It, however, does not work well when this information is not available or no analogous information is available around that asset in question. And that's where the challenge comes in, because each patent is unique. So to what extent you can find details of similar transactions for similar technology, it's pretty difficult. Now, In fact, the biggest hindrance to widespread application of market method is the absence of accurate and readily available data for comparable transactions, as I mentioned. Just think of it. Even geographical locations may have a relevance here because, for example, think of it. A transaction in US for a particular drug could be at a very different value than the transaction for the same IP for the same drug in India, because the pricing varies substantially based on the marketplace. Now, the market approach is subject to criticism even when data is available. So just think of it. It's not that only data availability is good enough. There are other challenges as well. This is because transactions may be different for various reasons, such as inclusion of non-patent assets in the transaction. So transaction may have a whole lot of things over and above patents, and that can bring in a lot of complexity to the methodology. So this is where we stand as regards the market method. Now let's look at the third classical methodology which is often used, which is income method. Now in the income method, it basically examines the future income generated by the patents and produces an estimate by calculating the present worth of those future cash flows or economic benefits. These are various there are various methodologies that can be applied using the principle of income approach, and these methods include, for example, discounted cash flow or relief from royalty are some of the options within the income method which can be considered. Now each of these approaches may be more applicable for different kinds of valuation scenarios. Think of it this way: the relief from royalty methodology, for example, is based on the premise that a patent value can be determined by what the owner would pay in royalty if it had to license the patent from a third party. Just to put it give an analogy around this, it is like, if you have a physical asset like a house, it would essentially mean that I have to assign a value to my own house depending upon how much rent I would be willing to pay for my own house to stay in this house if I had to get it from a third party. So this is how essentially, the income methodology vis-a-vis relief from royalty works. Now, on the other hand, another scenario is in the case of discounted cash flow methodology, where what happens, the valuer projects the appropriate measure of cash flow for several discrete time periods into the future. So there's a cash flow coming in future at different points in time. Those future cash flows are taken into consideration. And now how it works is the projection of prospective cash flows is then converted into current value, the value as of today, for determining the discount rate approach. Now this is how it works. So overall, if you think of it, the choice of valuation approach will largely depend upon the context of valuation and the asset being valued.
Thank you, Ravi, for this exhaustive explanation on different approaches. The paradox is that most of the approaches named as norms were basically not made for patent valuation. Some valuation methods were derived from company valuation, such as the income approach, and some from the accounting rules, such as the cost approach. This can lead to problems in applying the methods to all patents. Also, all the three approaches are quantitative approaches. And when valuing patent assets, it's highly imperative to consider the qualitative part as well. This brings us to our next question as to what are some of the qualitative factors that should be considered while doing patent valuation. The qualitative approach is focused on the analysis of the characteristics and the potential uses of the patent in question. It also considers the risk and opportunities with the patent asset. A comprehensive patent valuation can never rely purely on financial analytical data. When using the market or the income methods, a lot of factors affect the discount factor that needs to be applied in arriving at the net present value. Let's discuss some of these factors. The patent elements. The important patent elements could be the strength of the patent claims, the stage of the life cycle at which the patent is, and the opposition on the litigation status. To give you an example, if a patent is already at 15 years of its term, and considering that a licensee would need about 3 years to bring the product into the market, the remaining useful life for the patent would only be 2 years, and hence the value would be decreased as compared to a patent which is at the 10 years of its term. Additionally, comparison of technology with the other competing products is also important. Let's say you have come up with an innovative hand paper, but on comparison with the competing product, you realize that the market and demand for this product is very small, since the technology adopted by the competitor is more viable. Finally, due importance has to be given to the market elements. The demand in the market for patented product and technology, the existence of substitutes, the likely industry growth and the potential new entrants, and finally, the size and maturity of the market for the patent transaction. The value of a patent generally increases as the technology comes closer to the market, since the certainty surrounding the cash flow increases. A simple example of this is a biotech or pharmaceutical scenario, in which a patented product or technology goes through several regulatory phases, and therefore the chances of success increase over time. With this backdrop, we would like to quickly take you through some of the common steps performed in a patent valuation and what a valuation report might contain for you. The very first step would be to check whether the patent is in force. The first question, therefore, is to ask whether the patent's maintenance fees are up to date. If not, patent may be worthless. The next step would be to identify the context, as the premise can affect the conclusion of the patent valuation. The next most important step would be to gather information as much as possible. As a valuation analyst, you should inquire not only into the visible details pertaining to the patent, such as the copy of the patent or its renewal fee, but also the minute details of its prosecution and litigation. All of these constitute the qualitative factors that we discussed before. The other information that is important to collect is the details on the finance and the market side. This could include copies of any business plan, marketing study, financial statements, and available economic data on the industry in which the invention is used. Next, assemble a valuation team. A patent valuation team ideally should include a patent attorney and someone with proven economic skills, such as certified patent valuation analyst. Additionally, they should contain someone with business valuation skills. The next four steps, step numbers 5 to 9, are done to evaluate the patent strength. It is important to consider both the blocking patents as well as synergies, since a portfolio of related patents can be worth more to a single owner than the same patents would be individually to multiple parties. A very important step of the whole exercise is to consider the remaining life of a patent. As we saw before, for valuation, one must consider not only the legal life, but also the economic, technological, and regulatory life of the patent. The next three steps, step numbers 11 to 13, basically analyze the market and the demand for the patented product. The question to be answered here is that what is the expected level of revenues for the remaining useful life of the patent? Finally, determine which approach to use. Now this will be driven on the type of asset being valued, the date of the valuation, the context of valuation, and most importantly, availability of data. A cost approach is seldom useful, and the market approach may not be relevant because patents are unique. A word of caution for those who do use market approach here is that one must analyze comparable patents in detail, including their legal, economic, and technical differences. The income-based approach is most useful in case of patents, and variations of same are often used for valuing them. Finally, write the patent valuation report. The patent valuation report should document the patents valued, assumptions made, the limitations of the analysis, the procedures followed, and the conclusions reached, and most importantly, the date of doing the valuation. With this broad overview of several approaches and factors affecting valuation, let us now look at some live examples where patents and their valuations have played a critical role in transactions between companies. It is important to appreciate that even though value of a patent assigned may never be absolute, the patent valuation exercise in itself is critical and very much in existence since many years. Over to you, Ravi, for sharing your thoughts.
Thanks, Namrata. So as you rightly said, the patent valuation, even though being highly speculative, is indeed a reality. The value of a patent depends largely on its worth as perceived by the buyer. Now, it's usually difficult to segregate the value of the patent from, within a transaction. If it's a complex transaction comprising multiple assets, including, let's say, trademarks, trade secrets, contracts, and things like that. However, in some cases, the conditions are such that allow a reasonable calculation of the value of the patent, which is a part of a transaction. An interesting example is that of an acquisition that happened of VLI Corporation by this company called American Home Products, where during the pendency of the transaction, okay, when the transaction was still under discussion and negotiation, the target, that is VLI Corp's patent for its flagship product, lapsed due to failure to pay maintenance fee. Just think of it. Now, VLI Corp, in this case, what happened, was a manufacturer of a variety of contraceptives, and its main product was Today, a vaginal contraceptive sponge, which was protected by a patent issued in 1983, and it had a 25% market share for female contraceptives. Now, in 1987, the prospective buyer, that is AHP, indicated an interest to acquire VLI at $7 per share, which was cumulatively around 86 million USD at that point in time. Now, interestingly, shortly after this whole proposal came in, VLI, the target, learned that his patent had lapsed due to an inadvertent failure to pay the maintenance fee in US. Now, this was disclosed to the prospective buyer, and now the prospective buyer first said, okay, the deal will go through as long as you can reinstate the lapsed patent. Now, VLI, of course, petitioned to reinstate the patent at the patent office, but the same was denied in the first instance. Now, the counsel that was advising the target, VLI, said that, there's a significant possibility that even in the appeal, we might not be able to restore the patent. Now, this was, updated to the prospective buyer, and what the buyer proposed thereafter is that instead of paying $7 per share, they reduced the offer to something like $6.25 dollar per share, and ultimately the deal was finalized around it. Now, the question that you may ask is that, if the patent was at the heart of the entire transaction, then why is it that the prospective buyer went ahead and still had the deal done and bought the entire company, even though the patent at that point in time, at least at the first instance, was not reinstated? The possible answer for that could be that, even at that point in time, when at the first instance the revival failed, it was still possible to file further appeal for reinstatement. And just to let you know that ultimately the patent was indeed restored. Now, the other possible reasons why prospective buyer went ahead and paid still $6.25 per share was that uh, the target had an exclusive procurement contract with the manufacturer of the polymer which was used to make that sponge. So there was exclusivity around the polymer which will be provided for having that sponge being made. Now, any competing product, it is important, the FDA approval was there for this product, which meant that if any competing product had to come into the marketplace, it had to go through the regulatory approval process, which could be time consuming and expensive. So that also went in favor of, having this deal. Last but not the least is that the process to make that sponge was kept as a trade secret by the target, and that again added significant value to the transaction. Of course, there were also elements like trademarks and other elements. So in nutshell, often when you see the transactions like merger and acquisitions involving multiple assets, it is essentially difficult to assign a particular value to a patent, independent of so many other assets that might be part of the transaction.
Thank you, Ravi. Absolutely agree with you. The patent price in the VLI's case could ironically be determined because of the lost patent rights. Another classic example where it may be difficult to assign value to an individual patent is where the transactions are driven by purchase of large patent portfolios. Let us take you through some of them. 2011, following the winding up proceedings, Nortel, a major multinational telecom manufacturer, auctioned about 6,000 patents to a consortium of Apple, Microsoft, Ericsson, Sony, and others. In the following year, Google acquired Motorola Mobility for $12.5 billion to gain access to a total of 24,500 patents. Interestingly, in 2014, Google sold Motorola to Lenovo for $2.91 billion, but only 2,000 of the above-mentioned patents were transferred. In the year 2012, Microsoft also paid $1 billion to AOL for the 800 patents and a license covering 300 others. Experts believe that these patents gave strategic advantage to Microsoft, as Microsoft's patent filings cited heavily on AOL patents. In the same year, Facebook acquired 750 patents from IBM for an unspecified amount, which was speculated to be hundreds of millions of dollars. The year 2012 thus saw a large number of patent transactions where companies tried to defend a larger sector of technology protected by these patents and basically making it more difficult for the competitors to invent around. To conclude, we can say that patents are bets that the market will adopt your idea and would want to copy it. Until someone copies the patented idea, the patent has only a speculative value. In spite of this, whether it is to determine damages in a lawsuit or to have a higher negotiating power on the table, patent valuations have a large role to play. On this note, we thank you all for listening and we wish you safe times ahead. We are open to any questions that any of our live attendees have. Alternatively, feel free to contact us anytime. Thank you and take care.